Welcome to Cordell Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back to the Men's Divorce Podcast. Scott Trout here, CEO, Managing Partner, Cordell Cordell. And today we're going to talk about something that we haven't talked about in a while, which is really modifying child support and alimony or maintenance, whatever, or spousal support, whatever your state may call it. It's something we haven't touched on. And, in an economy that rides up and down, it's very cyclical. It's very relevant for individuals. I was just dealing with a client who was having me run some numbers on whether or not a modification of child support was warranted. So I'm joined by lead litigator Kevin Mammola over in Alpharetta, Georgia. Welcome, Kevin.
Appreciate it, Scott. Thank you for having me.
Yeah, thanks. Let's talk about Georgia. Obviously, in every state, they have their own particular rules, codes, sections, laws as it relates to it. But, the question always gets, and I get it a lot, what is modifiable? Can I modify property? Can I modify child support? That matters, obviously, state to state. So what is modifiable in Georgia?
So in Georgia, and I think it's pretty similar in most states, but I could speak for Georgia. You can modify the portions of a final decree that are modifiable are child support, alimony, child custody, and visitation. So those are three subjects. So today we're going to address the modification of child support and alimony. So that's what's modifiable here in Georgia, and the procedures are relatively similar for both. We can kind of get into those.
Yeah.
Okay.
Yeah. One of the things that we talk about the modification, this client I was dealing with yesterday, he and his ex-wife came to an oral agreement to modify child support. And they've been following that for probably at least 8 months. And of course, I came in, my red flags come right up and I'm like, here's the deal. So I know it's important and it's kind of a good place to start. Why should you be concerned about outside of court agreements, even though, you and your ex may be so friendly? Why should you be concerned about that?
That's a great question. That does come up frequently. Despite having a good relationship with your ex-spouse, you certainly never know what could happen in the future. But the law is that you can't deviate from what the court order says. Even if you and your ex, the other party to the court order, even if you both reach an agreement for an alternative payment, whether alternative amount or frequency of payments, that, in and of itself is not legally sufficient modification. So you actually have to obtain a court order that modifies the prior amount. And if the big, problem with doing that is that you can accumulate arrears or past due child support or alimony relying on this agreement with your ex, and you can use that agreement as a defense to being in willful contempt. You could tell the court, look, I didn't realize I was in arrears, so don't punish me. And they may not punish you, but you're still going to owe what I have seen is to be at times a very large amount, unfortunately, and there is no way to modify that amount. That is a judgment that cannot be modified, and that's unfortunate. So
and it's crazy. It happens so frequently. Like this client, they had this agreement, and the reason what precipitated his call was she said, now, I don't think I'm going to agree to that amount, even though they've been paying the lower amount for 8 months or whatever it may be. And now she wants all that money back. And I'm thinking we're in a problem situation here. Yeah. And that is, I know that's always the caution with clients is no matter how well you get along with your ex, when you come to modify support and alimony, just take that extra step and get it, signed off by the judge. Yes, it's an expense, but that comfort level of knowing the order is the order. And if you're following it, great. And that's the thing. So I think it's so important that any oral agreements related to that, go see a lawyer, go have a consult, figure out the right steps to get it official in the court file.
Yeah, exactly.
Yeah. So, okay, modifying. It's always a big question. What are the steps? What do I do? What do I need to prove? More importantly, what is it that I need to show that will kind of get me in the door? I always use that phrase. We want to get in the door to establish that there's some element that says, okay, I'm entitled to a change or a decrease or whatever it may be if you're the custodial parent increase. So what do I have to show?
So in Georgia, you have to show that there's been a substantial change in either party's income, whether it's increase or decrease, or the needs of the children, the financial needs of the children have changed. So in Georgia, what you'll typically see for modification is one parent's income has gone up or down, and that will get your foot in the door. There is no definition, unfortunately, of what constitutes a substantial change. But like you mentioned with your client that was calling in to talk about, the oral agreement with his ex, it's always advisable, to meet with your attorney, go over some scenarios to see whether your change in income would result in, a substantial change to the child support amount. And that's usually where we start, at least from a preliminary planning or perspective, discussing strategy is, look, do you have a case? And then do you have a case that you do want to pursue? So we want to see if your income's decreased by, 50%. Well, you probably do need a child support modification, would be my guess. But if your income's only gone down by 10 to 15%, you may want a modification. But after we do the child support worksheet or to calculate child support, it might not be worth it. It's just one of those things where you do want to see your options.
And sometimes it's a matter of factoring in attorney's fees. How much am I going to spend? And how much am I going to save? I mean, I've had guys come up and say, $100 a month will matter. But, their kids are like 16, 17, they're approaching the age of emancipation, and we're going to drop $5,000 on fees. And I'm thinking, you're going to wind up saving no money at the end of the day. It's kind of that kind of cost benefit analysis.
Yes, we always do that, and that's an important step. And I think that's something that should be discussed in the initial meetings to determine whether or not to pursue it. And then the other factor is to look into, your ex's income. Has that increased substantially? And you will see that often if they were, when you got divorced, if they weren't working, and now that they are. Let's just say they weren't employed at the time of the divorce. Their income was zero or very, very small. And then they go back to school and maybe they're like an RN. So they're making very good, presumably pretty good money. In that scenario, it's probably warranted. But again, we would run the child support calculator to make sure it's something that you should pursue. Because if you all of a sudden are making 2 or 3 times what you were making at the time of the divorce, it actually might not make sense to go back to the court to modify it. So those are things that all the factors need to be taken into consideration when determining whether to pursue it. But to get your foot in the door, yes, usually you'll need that. You do need that first substantial change in either party's income. And then as far as the needs of the children go, I do get that question from time to time. And I could say you don't usually see a modification pursued based on the financial needs of the children changing. Examples I think that may come into play potentially in Georgia, and maybe it's more so in other states. If somebody maybe has a special needs child and they have, it's recommended that they have a small class size and maybe they can afford private school, in which case modification may be warranted because of those costs. That's always a potential issue. So
is the term or is the standard in Georgia, because it's Missouri is a substantial and continuing change. And that's an interesting, is yours add that word or is it just substantial?
No, we don't. We don't, ours just says substantial change in either party's, I think income and financial status is how they lump it together, but we usually just look at income. I guess if someone won the lottery, I guess that's a change in financial status. So maybe that's where that comes into play, but we don't have a continuing.
The continuing tends to be maybe some of the reasons you can get kicked out and lose is it could be a temporary increase on the other side and maybe overtime, or it's something that is not permanent and a permanent change, or at least for the foreseeable future. And I've been up on appeal where we've been victorious in saying, it was a substantial change, but it wasn't continuing.
Wow.
And so it's an interesting burden. And so I think the reason I bring that up is, our listeners need to make sure that they have a consult, know exactly their variances, little nuances in every state as to what that standard is as it relates to child support. And it's obviously different with custody. We're not going to talk about that. But also we have a standard of kind of a presumption of 15 or 20%. In Missouri, that is kind of what we call a prima facie case of a change in circumstances that would warrant it or get you in the door. Do you have anything that has guidance from a percentage change in support?
Well, we actually don't within our child support statute. Now, there is child support services sort of has its own, I think, regulations. And I think within their regulations, there is some clause that addresses when they would pursue a modification on behalf of the children in that instance. And I think their threshold, it's something like 10 or 15%. And it may not be a change in income. I think it's actually if it's a 10 or 15% change in the child support amount, they will pursue a modification on behalf of the children. So I have used that guide as a discussion with clients. Hey, look, it looks like you may result in a 10 or 15% change in your child support amount. And even if it's a small change, we could probably sustain, we could defend them saying it's not a substantial change warranting a modification. And that's where that may come into play. Not frequently used in Georgia, but I do have some experience with those types of regulations with child support services. And I've used that in the cases we handle from time to time.
And one of the mistakes I've seen our clients make when they're thinking about a child support change is, when you mention administrative child support, there is this rule that the state here will only review child support every 2 years or every 3 years. And so that is somehow leaked out, and people think they can't change it more frequently. And that is just not the case. You could potentially have an order last year in December, and then a substantial and continuing change here happens in January, and you could be eligible for another modification. There's no minimum time frame, is there, in Georgia?
In Georgia, we have a 2-year rule, but it's a little tricky in the sense that what's weird about it is after the final decree is entered, you can file for modification of child support a day later, theoretically, if you can show the substantial change in financial circumstances. But after that first modification order is entered, you're actually precluded from pursuing that modification again for 2 years. But there is a caveat to that, like a lot of our laws have. And that caveat is unless you have an involuntary loss of income equal or greater than 25% of your, or equal to or greater than 25% of your income. So if you've lost your job, you don't have to wait 2 years, which is a good caveat to have, I suppose. So there are circumstances where you could be, I guess, addressing multiple modifications in multiple years, depending on the economy and maybe what that person does for work, if they're in an industry that's kind of going up and down.
Right.
And we saw a lot of that, after the housing crisis in 2008-9. Interestingly, that's when Georgia actually implemented that law, was in 2007. Before that, you had to wait 2 years, oddly, no matter what. So now you don't. We did utilize that a good bit when people were, going in and out of work, depending on the industry that they're in.
Yeah.
So.
Interesting. When you think about child support, we're talking about reduction. The same standard goes for our clients who are trying to defend against an increase. So it's got to be a substantial change that the other side has to prove. So, I think a lot of times we're always thinking to clients, hey, bad economy, your income's gone down, your bonuses have gone down, or she's making a lot more money. But the same goes for defense, right?
Exactly. Yeah.
So, a big question. I know Georgia differs substantially in Missouri on this issue. I'll talk about Missouri in a minute, but retroactive modification, that's a huge one. So what is Georgia law on retroactive?
So Georgia does not have retroactive modification. If you're initially establishing child support, you cannot go back in time and ask for, retroactive child support. The only we don't call it retroactive modification, but if you do lose your job where you have a loss of income equal or greater than 25%, the judge can go back and adjust your child support arrears if they've accrued, meaning, and the judge can only go back to the date of when you initiated the case. So if you do lose your job, we always recommend you probably should pursue, unless you have something lined up right away, you should probably pursue the modification of child support as soon as possible. Because when you do file it, if you have a hearing, the judge can go back to the date of filing and say, well, you should have actually been paying this much. So therefore, I'm going to either, wash away your arrears or reduce them. So to a certain degree, you can look at it like retroactive modification, but it's not called that in Georgia. And we always tell everybody we don't have that here, but there's just a small caveat where you can maybe adjust your arrears if they've accumulated. That's what that is.
Yeah, so that's the difference with us. Yeah. And we have this retroactivity to the date of filing. And that's why we always encourage clients, don't wait. Obviously, if you've lost your job or decrease in 25%, certainly don't wait. But there is this rush. If you feel like you have grounds to modify, get filed, because it's always in our request is retroactive to the date of filing. And That's something that it can add up very quickly considering post-COVID now. In Missouri, a case before COVID would take 6 to 9 months from filing to trial. Now you probably could be a year to 2 years, which now isn't unusual. Our systems are so backlogged, just trying to kind of flush out the 2020, 2021 filings. So retroactivity is a huge consideration for us in Missouri. But again, another reason to sit down with a lawyer where you are and find out, because it can be a big benefit. Yeah.
Exactly.
So new spouse, that's another question. I'm divorced. My ex gets remarried. He makes millions of dollars. And now I'm angry because they don't need my child support. Does it matter?
Yeah. Unfortunately, no. It is always going to be an issue between you and your ex-spouse and the child or children you have together. So from that perspective, I do get it, but I also get the perspective of the new spouse has all this extra money. Why do I need to keep paying this amount of support? Unfortunately, that isn't going to be a factor. The only factor I would address there is you could be reassured that your ex-spouse can't quit her job because she's now remarried and ask for more child support because her income has gone to zero. So that she can't do. The court won't allow her to just, stop working and ask for more child support because somebody is supporting her. So in that regard, we can use those facts here in a modification or maybe defending one. But the new spouse's income will never be included in the child support calculation here in Georgia. And I assume that's probably the case in most states. But
it is, right. I mean, it does apply to some extent, and it's a good pivot for us to talk about alimony or maintenance or spousal support. Yeah. We'll get to that in a minute, in that topic, and whether maybe boyfriend, spouse, income, who contributes to a household matters in Georgia. But I think the first thing to identify when you're thinking about you have an alimony award that you have to pay is it modifiable? And I think they're probably very similar across the states, but there are two types of alimony, or it depends on which is modifiable and which isn't. But what is modifiable in Georgia?
That's a great question. So in Georgia, we do have lump sum alimony and periodic alimony. And I'm not sure if they have used those terms in Missouri. We cannot modify lump sum alimony. Lump sum alimony is it could be a one-time big lump sum, or it could actually be fixed payments over time. And I'm glad you brought that up, because it's a great point, because I've had potential clients come meet with us and show us a settlement agreement that they entered into without an attorney with their ex. And the way the language was drafted, it was non-modifiable because of the way it was structured. So that's actually a great point. That is very important, that everybody going through a divorce that potentially is going to pay alimony has the correct language regarding alimony in there, because you can make a mistake and it will be non-modifiable. And by non-modifiable, it literally means even if you become disabled and can no longer work, legally that money is still owed, and the other party can collect against it, unfortunately. Yeah,
it's a danger. Like you, I've seen many draft or final judgments that where our client was pro se or represented themselves or had a lawyer that probably they shouldn't have hired. And I'll go even further. We have similar types of alimony here. We just call it a term or defined over a period of months or years, and then open-ended periodic, where our client agreed to open-ended until you die or remarry, but it was non-modifiable. And I mean, it was forever. And it's crazy. Why? Yeah. I mean, it's no lawyer. I would never, I don't care how rich the other part of the deal was, never recommend to a client to sign a non-modifiable, open-ended, forever till death do we part type of, agreement. And that is so key so that's why everyone says, oh, I'm paying alimony. I'm like, well, I need to see your agreement. I need to make sure that we have the ability to modify it. And that is key. So when we talk about modification of alimony, similarly, let's just make the assumption, yes, okay, we can modify it. What is the standard the same as child support? What's the standard in Georgia to consider?
So the standard is actually pretty similar. The way the language is crafted, I think it says that you can modify alimony based on if either party has had a substantial change in their income and financial status. So the term financial status, again, gets thrown in there. It's sort of gray area. We usually will look to incomes primarily. And the criteria is similar to child support. The difference is that there's no alimony calculator in Georgia. So we can't plug in the new income for our client and then his ex-spouse. What we would be doing in that instance, though, is saying, okay, with the income that you now have, are you able to meet your obligation? Well, if it looks like you probably can't, then you probably need a modification and we need to pursue it. So it's a little less of a science, I guess, as far as the child support modification goes, because you have the calculator there. This is a little bit more of an art, I guess, with alimony. And you're going to want to be talking to someone that has experience with the judges in the locality, in the area that you're working in. And typically we can provide some pretty good guidance there based on our experience as far as what modifications, may be warranted in this particular case. But ultimately, you would be doing a similar analysis in the sense that you would be saying, all right, if you're obligated to pay $1,000 a month and your income has gone down to this amount, or maybe her income has gone up, to whatever amount you think it has gone up to, do we think the judge is still going to make you pay this amount of alimony? So we have to do an analysis there. And again, it's no calculator telling us one way or the other, but usually we can provide a pretty good idea as to whether or not that amount's going to get knocked down. If you've lost your job, it probably will be. If she was unemployed at the time of the marriage, but now she's working in a good career, it's probably modifiable. To what degree it's going to go down, it's hard to know. And then I think along those same lines, we were talking about what's modifiable within the realm of alimony. So we have in Georgia, and I think like most states, if you have a term of alimony, let's say it was 5 years, we actually can never modify the term. So right. Even if the facts warrant a modification where you shouldn't pay alimony, the way it would work is you would have a zero alimony obligation for the remainder of the term. And it actually does give the other party, your ex-spouse, the potential to bring you back to court for alimony again. But I usually don't see that happen, but it's just something that is a little bit, of a tricky area under the law, but you'd have a zero alimony obligation for the remainder of the term. That's how it works.
It's an interesting twist. We can't do that. Let's say I agree to a 60-month term, $500 a month. It doesn't matter what happens in the world. I am obligated to pay that, and that actually goes into my estate if I die. And that is a debt that is an unsecured debt, but it's non-modifiable no matter what. And that's always the risk. And I always say there's risks with a term because it's forever money. I mean, during the term, it doesn't matter what happens. If she wins $1 billion Powerball, still got to pay it. If she marries a billionaire, still got to pay it. You get run over by trucks, still got to pay it. And so there's some risks. And I really, I'm jealous of the states that have this. And I know you mentioned no calculator, that do have a way of calculating maintenance. We do not. And it's judge to judge. I could present the same facts to the same judge on different days and get a different result. And
that's what's like here.
It is. It's so frustrating. You go to Kansas, or I think it's Texas, and it's maybe a maximum of 121 months, depending upon the length of the marriage and a percentage of your income. So nice to be able to advise clients of that. Yeah. And likewise, it's very difficult to advise clients on the modification of what, for me, well, how much will my alimony go down? Well, that's a hard, thing to tell you. But we have some non-statutory, non-case law guidance based on county to county around here. We know what judges are thinking, but there's no law to support it. So we can kind of give some guidance, but then that brings up retroactive. Can you get retroactive alimony reduction to you or not?
So in Georgia, unfortunately, you cannot. And we don't even have the same sort of, I guess, adjusting of the child support of the arrears like we do with child support. There's no provision in Georgia that actually will retroactively modify any portion of the alimony awards. So that being said, that's actually very important that you do file for a modification of alimony sooner rather than later, because you may not get into court, like you were touching on how long it could take to get in front of the judge. We have the same issues here. It is, county to county, but as a rule, I would say 8 to 12 months at a minimum is how long it would take for you to get in front of a judge. So every month that goes by, that alimony obligation is going to be due and payable, and it will remain due and payable until there's a new order adjusting it. So if you feel that you need a modification of alimony, that's one of those things you should jump on, and consult with an attorney as soon as possible to determine whether or not it makes sense to do it.
And that's a good way to kind of wrap up our podcast in terms of consulting with an attorney. And I've always said, we tend to take better care of our cars than we do ourselves post-divorce. And so, we're always going in for an oil change. And while you're in there, just check everything, make sure everything's good. So they check the brake fluid, the radiator fluid. They check it all. And they're like, everything's A-okay. And we're like, okay, whew. So, load off my mind. You should do the same thing in your divorce decree. Go in, whatever, every 2 years and just have a checkup. Hey, would I be eligible? What's going on? How the laws have changed? Is my alimony, is it modifiable? What would it take? Here's what I know about my spouse. Here's my income. Can you run a new child support chart for me? Can you run this? I think that, as we talk about, it's the best hour of investment you'll make every year or every 2 years, just to see. There was other provisions about, aside from what we're talking about, especially in Missouri, revival of judgments. If you haven't done anything to kind of pursue the division of retirement, and there's a statute of limitations on that if you don't do anything and you don't take action to either do it or revive it, you lose it. I've had clients come to me and it's 7-10 years later and they're like, well, yeah, I forgot to get the pension. Well, I'm sorry, the statute's run. Yeah. So I think, as you mentioned, consult with a lawyer, have a checkup, whether it's every 2 years, every year, whatever you feel comfortable with. That is so critical to do. And I imagine you would feel the same way.
Absolutely. Yeah. That's a great way to put it. Yeah.
Yep. Well, Kevin, thanks for joining it. Great topic, child support alimony, the ins and outs. Appreciate you joining today.
Thank you, Scott. Thank you for having me. Appreciate it.
Well, give us a call, schedule a consult. Kevin's available. You can schedule with Kevin if you're in the Georgia area. You can go right online at CordellCordell.com. You don't even have to pick up the phone. Type in your zip code, type in a city. It'll tell you what our closest office is to you. Or we can do it via Zoom, via phone, in person, whatever is convenient and comfortable for you. CordellCordell.com. Or you can give us a call, 866-DADS-LAW, 866-DADS-LAW. So continue to tune in. And if you haven't joined our live Men's Divorce Live podcast, that's every month, where you can log in for 30 minutes, ask questions of our attorneys live and get answers right then and right there. Check it out at CordellCordell.com. Also on our social media, it's free. You just have to register and you can log in and log on and ask all the questions you want. So until next time, have a great week.